Obstruction, retaliation. What are these charges? How can a police officer charge you for this crime in Texas? Hi, I'm Jeff Hampton with the Fulgham Law Firm. Today I want to break down the law of retaliation/obstruction, which essentially I want to identify the difference between the two and how do you know if you're doing something out of retaliation or obstructing as it's defined under Texas law. And by the way, if you wait around to the end of this video, I'll also get you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Okay, so let's talk about this for a minute. Here's what happens very frequently. If some witness or somebody claims that you acted in some way out of retaliation for something, many times what will happen is that witness will contact, maybe even an officer will contact a detective. That detective will then want to give you a call. So what should you do if a detective calls you and says, hey, you are now the subject of an obstruction or a retaliation criminal investigation? Well, first of all, be aware of their tactics. Detectives are trained, and I'm not faulting them for this, but I'm just telling you the way it works. Detectives are trained to try to call you and ask you to tell your side of the story. They'll say, hey, listen, man, maybe we have a misunderstanding. Why don't you come on in, sit down with us, let's go over it, and we'll square it all away. The problem is telling your side of the story is the very last thing that will happen. Most likely what will have happened is that the officer will have already questioned the alleged victim or the witnesses from whoever's involved in this, and they'll already have an idea in their mind of exactly what they think happened. So if you go in and you meet with them, what's going to end up happening is you're going to be interrogated, they are going to pelt you with questions, and unless you give them the answers that they want, which are what? Yes, I did that. Yes, I said these things. If you say no, then what are you being? You're not being honest. You're being evasive. Those are all things that the detective will determine they believe make you look guilty. So you kind of win. You can't win either way, especially if you're trying to be honest about what happened. Now, the way around that is, here's the thing. So many people make the mistake. Innocent people make the mistake of wanting to go in and clear the air and just go in and talk to that detective about it. But you have a Sixth Amendment right to counsel, and you have a Fifth Amendment right to not have to go in and answer an officer's questions about anything, and you need to protect yourself. A good criminal defense attorney acts as a firewall between you and the state of Texas. That way you can make sure information that's fair and exculpatory, that shows maybe you didn't do anything wrong, that can be shared with the detective without it being twisted and turned. And even if you did do something wrong, you don't need a police officer or a detective trying to take any statements you make and trying to make it worse and trying to make it seem like you confessed to something that maybe is not accurate, okay? So one of the common techniques used by criminal investigators is to ask you questions about surrounding facts that will make the state's witness appear more credible. If you say yes to a lot of the same things that the so-called witness said or the so-called victim said, it makes that witness appear to be more credible on the surface, even though you're not confessing to anything. So to be smart about the situation, you should contact an attorney, have the attorney help walk you through that process. Now, what does it mean to be charged with obstruction or retaliation in Texas? Now, to simplify this law, the crime of obstruction or retaliation, essentially what does it mean? It means it criminalizes threats made against judges, police officers, public servants. If you make a threat against a police officer, a judge, or other public servant as defined under the law, or you publicly post contact information regarding a public servant or their family member, you could be facing a very serious felony charge under Texas law. So under Texas Penal Code, section 36.06, a person commits the criminal offense. Let's first look at retaliation. The criminal offense of retaliation, if he intentionally or knowingly harms or threatens to harm another by an unlawful act in retaliation for or an account of the service of status of another as a public servant. So here's what it is. It's harming someone or threatening to harm someone because they're doing their job as a public servant or as a witness, prospective witness, or an informant, or a person who's reported or who the actor knows intends to report the occurrence of a crime, or to prevent or delay the service of another as a public servant, witness, prospective witness, or other. A person can also commit an offense if the person posts on a publicly accessible website the residence address or telephone number of an individual the actor knows is a public servant or a member of that public servant's family or household with the intent to cause harm or a threat of harm to the individual or a member of the individual's family or household in retaliation for or on account of the service or status of the individual as a public servant. So one, it has to be done to a public servant or a witness, but it also must be done with the intent to cause harm or a threat of harm to that person, okay? Now, very quickly, is there a difference between obstruction and retaliation? Well, the primary distinction, this is very important, the primary distinction between obstruction and retaliation is when the harm or threat of harm supposedly took place. Did it take place before a public servant or witness did something or after they did something? Now, what do I mean by that? Obstruction involves a harm or threat of harm to a witness or public servant before that public servant has done their job. The act, say reported the crime or done the arrest. And we've seen people do this before. They say, officer, if you arrest me, I'm going to do this, or I'm going to do this to you, or I'm going to do this to your family. So the question is, did it happen before or after? Obstruction is defined as the act of delaying or preventing someone's actions. So it's delaying or preventing someone's actions as a witness, informant, whistleblower in a crime, or as a public servant. So to be convicted of the crime of obstruction, it must be proven by the state of Texas beyond a reasonable doubt that you caused harm or threatened harm that was unlawful. And the harm or threatened harm can be physical, but it can also be non-physical. For example, you can make threats to cause property damage. You can threaten to destroy something. These threats must be proven to have been made. Here's the key though. The threats must have been proven to be made to prevent that public servant or witness from doing their job or offering the testimony. So the threat must be tied to that public servant or witness's giving a testimony or doing their job. Okay, that has to be tied to it. It's kind of a conditional. If you do what you're supposed to do, I'm going to do this to you. Or if you testify against me, I'm going to do this to you. If you arrest me, officer, I'm going to do this to you. That's the kind of example we're talking about, all right? Now, one of the things we talk about with the crime of retaliation is related to the act of harm or threat of harm to a witness or public servant after a crime has been reported. Specifically, if the state of Texas can prove beyond a reasonable doubt that you harmed or threatened to harm a public servant or witness for doing what? You gave testimony against me and I'm going to do X to you, right? If, officer, you arrested me, so now I'm going to do this to you. This can now be the basis for a retaliation charge. So we are looking at a threat because someone reported a crime or acted upon their duties as a public servant. That's the difference. One, obstruction is before something's been done. Retaliation is in response to something that already has been done, all right? So the whole spirit and purpose of this law is to prevent illegal acts against someone that's doing their job in the criminal justice system, whether it be a witness or a public servant, all right? So the most common situation where retaliation charges are filed is when a defendant makes a statement to a prospective witness or an alleged victim in pending cases, and what do? Like, you know what? You know what really happened here. You know, if you get up there and you testify, I'm going to make sure your life is just horrible because you're going to be lying against me. Well, what ends up happening? That person ends up overreacting to what they hear. They take that statement as an express or an implied threat. So be careful what you say to people, all right? Very important. They'll take it as an express or implied threat and report it to the district attorney's office. Now the district attorney's office sees this and they just line in that they think they've got a retaliation or an obstruction charge. So the question is, are these two crimes, obstruction or retaliation, are they a felony in Texas? Yes, they are. They are a felony of the third degree. So you're talking about third degree felony, punishable by a minimum of 2, up to 10 years in prison, and up to a $10,000 fine. However, if the alleged victim of the offense was harmed or threatened because of their service as a juror, it can make it a second degree felony. So don't threaten jurors, right? That's basically what they're saying here. There you can be punished by up to 20 years in prison and up to a $10,000 fine. Very quickly, what are some of the defenses to obstruction or retaliation? One is a lack of criminal intent. The state of Texas must prove that the statements that you made were made with intentionally or knowingly looking to harm or threaten to harm someone as a result of them acting as a public servant or a witness. And so what do we mean when we say intentionally or knowingly? Well, here's the thing. That language makes it certain that the harm that was caused or the threat of that harm must have been made specifically to the witness and with that criminal intent. What if it was made accidentally? What if it was made mistakenly? What if it was stated negligently but not directly at or with the criminal intent necessary? If a threat was made by a defendant but there is doubt regarding the object of the threat, maybe there was something said, but that could have been made to someone else and not necessarily to the officer or not necessarily to the witness. And that's a big deal. And I'm going to share an example with you. We did represent a client one time where charged with retaliation for making a threat of harm. The police officer believed that the threat was being made to him and he became enraged. So he arrested them for the crime. The problem is you review the video, the body camera, you look at all the evidence about what actually happened. It became much more clear that our client was actually making the threat to another witness who was there, egging him on and trying to do certain things because he was observing what was happening. The threat was not being made to the officer. Well, that was critical. It's important because you must tie the threat specifically to a witness giving a statement or specifically to a police officer doing their duty and doing their job. Okay, so and the way we did that, because this is a felony, we helped prepare a packet of evidence that we could present to that grand jury so that the grand jury would see what actually happened on this. And that helped our client by him being able to avoid a felony charge and getting his case thrown out. Finally, the last one I want to talk about is what if the threat, a defense here, what if the threat itself, so-called threat, cannot be proven? Now, we've learned about this. The state of Texas must prove that the harm was done or a threat of harm was made against a witness or a public servant. But what if the threat was not really a threat at all? What if it wasn't actually objectively a threat? What if it was a statement made full of rage, full of anger, very upset in the moment, but very non-specific in terms of what was actually said? One important point to make is, I know we've talked about this, it doesn't have to be physical harm, it can be property damage. But if the alleged threat of harm was more frustration, what if it was more lacking specificity? There's nothing that's, look, I'm sick and tired of you, I'm tired of this. I'll tell you what, if you do this, I'm going to do this, but it's very vague. You can just tell somebody's very mad, very upset, speaking out of anger, but there's no specific threat or specific harm that's being threatened. Your criminal defense attorney needs to really grab a hold of that because that may not be specific enough in order for the state of Texas to prove the crime of obstruction or retaliation. So here's the thing. If you or a loved one are facing an obstruction or retaliation charge in the North Texas area, I want to invite you to call the Fulgham Law Firm. You see this number that's above me that's been up here the entire time. Call this. We'll give you a free consultation and a free case analysis if you have a case in the North Texas area, and we'll be happy to break this down for you and help you start preparing your criminal defense. Now, I promised you if you waited around to the end of the video, I would also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Click the link down here below into the YouTube video. We'll send you over that by email, that ebook for you so that it'll help you in your preparation for your defense. And I want to thank you for joining us here today. Listen, if you've liked what you heard, check out our other videos. Subscribe to our YouTube channel, like this video, and we'll continue to send you great criminal content just like this. All right, thanks again for joining us. We'll see you next time.